Hi, this is Dr. Perry Carpenter. I'd like to thank you for taking the time to join me on this week's video. In this week's video, we're in session number 5 of our new series entitled Combating Bias in the Medical Legal Evaluation. And today I have some groundbreaking, incredible, awesome, great news, fascinating information to share with you about recent changes in our system that are going to mark the beginning of a brand new era. This video is being recorded in early September 2021, and we're on the cusp of making new history again in the medical legal evaluation. You know, in summary, if we look back at the year in retrospect and look at some of the changes that we've been through as a group, as qualified medical evaluators, and the system in general, this has been a year of tremendous change for all of us. We have this year we have a brand new medical legal fee schedule which has changed everything. We have new proposed changes to the QME regulations which effectively dramatically change, if not completely change, all of our administrative and office operating procedures. So that's 2 sources of new changes. And then we're on the cusp of seeing past the DWSC's new anti-bias regulations, which will probably come into effect 1/1/2022, but which are now beginning to gain momentum and cause ripples throughout the system. And these are changes that you would be well served to adopt early, even before these regulations become official law on or about 1/1/2021, because they're coming and you might as well get a jump on the new thinking and the new way of operating as a qualified medical evaluator. And what I want to share with you today are some more examples of how the system is moving toward an unbiased, non-discriminatory, non-stereotyped medical legal evaluation with you as the qualified medical evaluator as the captain of the ship. So I have a fascinating revelation for you today which is going to blow your socks off just as it did mine. So before we get into today's discussion, let's just review the purpose of this program in its entirety. And the purpose of this program is to explain to you how the Division of Workers' Compensation's plan to combat bias in, number 1, the medical legal face-to-face evaluation, number 1, face-to-face, and then number 2, how the DWC's plan to combat bias in your QME reporting, how those 2 plans are expected to impact you as a qualified medical evaluator. And then if you can understand how that's going to impact you, and if you can trace that back to the division's plan, you can then understand and determine how you can arrive at opinions and conclusions in the body of your report and write your report free from bias so that appropriate benefits can be provided for all persons. Because the problem with bias in the medical legal evaluation, and there's pro-bias and there's anti-bias, and bias goes in both directions. But the problem with bias is that bias in the medical legal evaluation leads to the provision of workers' compensation benefits that are not accurate. They're not accurate. They're skewed. They're skewed either to the left or they're skewed to the right, but they're not accurately pointed down the middle at what's true and at what's accurate. And the whole purpose of the systemic changes that we're going through here in 2021 are to improve the accuracy of the system. So that's the purpose of this entire program. And before we get into the topics of today's discussion, let's just briefly review where we've come from so far in this program. In session number 1 of this program, we explored the origin of the concern for bias in the medical legal evaluation, and we discussed at great length the groundbreaking and historic Page versus Perry Soto lawsuit. Now, while many of us may look at the Page versus Perry Soto lawsuit as the event that started the DWSC's movement toward the new anti-bias regulations and towards implementing anti-bias training for all of us as qualified medical evaluators, it's probably more accurate to say that the Page versus Perry Soto lawsuit represented the final straw that broke the camel's back, that finally brought the system to its knees, to the point where the system had to finally address bias in the medical legal evaluation. So rather than being the origin of the concern, this was probably the more aptly phrased the cause of the wake-up call for the division and for all of us involved in the evaluation of injured workers. And in session 1, we answered the question, does bias exist? Does it actually even exist, or is it just a legend? Does it exist in the medical legal evaluation? And the Page versus Perry Soto lawsuit confirmed that indeed, not only does bias exist, bias has been long rampant, pernicious, and prevalent in the medical legal evaluation. And it was these brave women in the Page versus Perry Soto lawsuit, these were women who were alleging gender discrimination in the workers' compensation system. It was these brave women that had the courage to come forward to reform the system. And now here, 5 years later, we're on the cusp of seeing their efforts realized. And today I'm going to share with you the first domino in the chain falling. The first domino has just fallen toward a new and reformed system, and we have the Page versus Perry Soto lawsuit to thank for it. In session number 2 of this program, we took a look at the extremely comprehensive plan of the Division of Workers' Compensation to eliminate bias in the face-to-face evaluation and in the opinions and conclusions of the QME. And this is a fascinating study. What the Division of Workers' Compensation has done is they've taken a look at the entire life cycle of the qualified medical evaluator, from the point in time when the qualified medical evaluator sits for the QME competency evaluation, in other words, at the inception of the QME's career, all the way through the life cycle of the qualified medical evaluator until such time as the qualified medical evaluator becomes unavailable or retires or dies. The entire life cycle, the Division of Workers' Compensation has a plan for educating the qualified medical evaluator on issues related to bias and on issues to eliminating stereotyping from our opinions and conclusions all along the career of a qualified medical evaluator. And so this is a fascinating and very comprehensive plan that I'm sure took quite a bit of timing, planning, and consideration to come up with such a thoughtful and comprehensive plan. And this plan indicates the Division of Workers' Compensation's serious intent to attack the pernicious problem of bias in the medical legal evaluation. So at the end of that discussion, we took a look at the question, can a biased species, such as the qualified medical evaluator, can this biased species of creature roaming the earth and coming face to face with injured workers, can this species be rehabilitated? Is there hope for eliminating bias, eliminating discrimination, eliminating stereotyping, and eliminating all of these preconceived notions and pre-reflective attributions that we have when we socially categorize the people with whom we meet? And the answer to the question is a positive yes, In fact, we're starting to see now reforms taking place right before our very eyes. And specifically, I want to share with you a brand new happening having to do with the passage of Senate Bill 788. Now, Senate Bill 788 has been struggling for passage for at least a couple of years. And the purpose of Senate Bill 788 is to reduce the bias in the qualified medical evaluation's apportionment determinations. And this can trace back to the Page versus Perry Soto lawsuit, where women injured workers showed evidence that qualified medical evaluators' opinions and conclusions on apportionment were unfairly and unlawfully reducing their permanent disability awards because those apportionment approximate percentages that were provided for by the qualified medical evaluator were biased. They were based on assumptions and preconceived notions about gender, about the female gender, and also about women's reproductive biology. And in the Page versus Perry Soto lawsuit, one large segment of the females who came forward during that lawsuit were known as the apportionment class, and these were women who had had their permanent disability awards reduced unlawfully and unfairly on the basis of unfair and biased apportionment. So the apportionment class has had their dream and their vision realized through the very recent passage in July 2021. This is being recorded in early September 2021. So just a few weeks ago, Senate Bill 788 finally passed the legislature. And the purpose of Senate Bill 788 was to rewrite our apportionment labor code 4663. So let me read a couple passages from this for you. And you can see here I have Senate Bill 788. It says right here, 788. This is California legislative information. So this just passed June 17, 2021, so just a very few weeks ago. And it says that this bill would prohibit consideration of race, religious creed, color, national origin, age, gender, marital status, sex, sexual identity, sexual orientation, or genetic characteristics, or sexual orientation a second time, to determine the approximate percentage of the permanent disability caused by other factors. Other factors. This is the factors to which the disability award can be reduced through apportionment. This bill would also express the legislature's intent to eliminate bias and discrimination in the workers' compensation system. So it's happening. It's now happening. This is the first domino falling. So this is the first domino. The other dominoes, consisting of the Division of Workers' Compensation anti-bias regulations, those dominoes are going to start falling approximately 1/1/2022 when the new proposed QME regulations pass, and they will pass, and those dominoes will fall at that time. But the cascade begins now officially in law with the passage of Senate Bill 788. So the final conclusion of Senate Bill 788, let me read it to you here. This is Labor Code 4663 now rewritten, and you'll recognize this language from Labor Code 4663, but it's been tweaked a little bit. It says, and you'll recognize this language, 4663, Section C, Section 1. In order for a physician's report to be considered complete on the issue of permanent disability, the report must include an apportionment determination. We already know that. That's not new. A physician shall make an apportionment determination by finding what approximate percentage of the permanent disability was caused by the direct result of injury arising out of and occurring in the course of employment, and what approximate percentage of the permanent disability was caused by other factors, both before and after the industrial injury, including prior industrial injuries. And that's not new. That's the same language that we've known, but here comes the new amendment to Labor Code 4663. It says, ding, 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 and this is it. This is it. This is the successful work product of the Page versus Perry Soto lawsuit. It says, the approximate percentage of the permanent disability caused by other factors shall not include consideration of, and here are the targets of bias that the legislature has decided upon. shall not include consideration of race, religious creed, color, national origin, gender, marital status, sex, sexual identity, or sexual orientation. And I'm going to share with you as we go throughout today's discussion some cases where qualified medical evaluators have opined with racial bias. They have opined with bias based on national origin. They have opined based on bias associated with sexual orientation. But those days are now over, and that's a good thing. Okay? So that was what we discussed in session number 2, and we're now seeing the results, the long-term results of the efforts of the Page versus Perry Soto lawsuit now coming together and being blended and combined with the Division of Workers' Compensation's plan. In session number 3, we took a look at bias underneath the microscope, and we defined bias through the consideration of the concept of social in-groups and social out-groups. And we took a look at various combinations of players, of parties that could fall within our social in-group, and contrasted those with those that could fall within our social out-group. And we saw how the distribution of persons and parties into either in-groups or out-groups affected the opinions and conclusions of the qualified medical evaluator. So you will always tend to favor and opine in favor of persons who you determine to be in your in-group as a qualified medical evaluator. And you will always burden or punish those who you determine to be in your social out-group. And you favor with your opinions and conclusions, and similarly you punish and burden with your opinions and conclusions. Very fascinating concept. And then in session number 4, we took a look at the various types and targets of bias in the medical legal evaluation, and we defined the types of bias by looking at unconscious or implicit bias, or unconscious or implicit stereotyping. Those are synonymous terms. And we contrasted that with conscious bias compared to unconscious bias. So there was conscious and unconscious bias. And then we took a look at the targets of bias in the medical legal evaluation, and we learned that there were 2 targets. There are person targets, there are people targets. People like the claims administrator, the defense attorney, the applicant attorney. These are person targets of bias. And then we looked at characteristic targets of bias, such as color, such as age, such as weight, such as physical conditioning, and all these characteristics that we use to socially categorize people, and all of these characteristics against or in favor of which we have implicit and unconscious biases. And these 2 sessions answered the question, are your opinions and conclusions, yours, the qualified medical evaluator, are your opinions and conclusions influenced or impacted by either your conscious or your unconscious biases? And the answer, which could almost be no other way without an awareness of these issues, the answer could be none other than a resounding yes. Yes, we are a biased species. We express our bias in the opinions and conclusions that we offer in our reports, and the problem with that is it results in determinations that are not accurate. And so the new system, the new era, the new changes that we're seeing in legal law, such as Senate Bill 788, and in legal law, such as the passage of the new proposed QME regulations, is to once and for all shake these considerations out from our opinions and conclusions by causing us to first think about it, and to put some long, hard thought to our opinions and conclusions before we put pen to paper. So to help you see how some of these various biases play out in the system, I want to share with you several case examples. Okay, so in today's discussion, I want to share with you several case examples, actual case examples published in the system that deal with bias. So I want to show you some examples of bias in the medical legal evaluation and then also in workers' compensation in general. So I want to share with you a few more details about the Page versus Perry Soto lawsuit so you can get some insight as to gender bias and how that plays out in the opinions and conclusions of the QME. I have a case to share with you where the qualified medical evaluator was found to be providing an opinions and conclusions that were biased based on the injured worker's nation of origin. I have a very fascinating case to share with you referred to as Beecham versus Swift Transportation, where the qualified medical evaluator was replaced due to her opinions and conclusions that were very and quite obviously racially biased. I have a study to share with you that demonstrates some of the bias in the workers' compensation system in general, and it shows what populations of persons most commonly are filing workers' compensation claims and how that disproportion plays out in the distribution of workers' compensation benefits. And then finally, I have a fascinating case to share with you, which involved very high dollars, by the way. Not a workers' compensation or medical legal evaluation case, but a case which clearly demonstrates what's referred to as disability bias, where the employer fired a formerly injured worker on the basis of some residual disability that the injured worker suffered as a result of an on-the-job injury at the same employer. So this was a very high dollar case that punished the employer with punitive damages for disability bias. Okay, so let's take another quick look at Page versus Perry Soto and the issue of gender bias in the medical legal evaluation. So in the Page versus Perry Soto lawsuit, many women, thousands of women. Now, the lawsuit is not entitled Thousands of Women versus Perry Soto. It's referred to as Page. And Page was one of the women, but this lawsuit actually involved thousands of women. And these thousands of women came forward and they alleged that California's system of workers' compensation perpetuates the type of overt sex discrimination, and by sex they're referring to gender discrimination, that is a relic of a past era. It deprives women workers of fair compensation on the basis of stereotypes about gender and a woman's reproductive biology. Specifically, they stated, the workers' compensation system unlawfully discriminates on the basis of gender. They meant gender when they said sex. We can consider that to mean gender. In the calculation, important word here, calculation, of permanent disability benefits, which benefits are intended to compensate injured workers for long-term physical loss and loss of earning capacity, that it discriminates in the calculation in two ways. And they went on in this lawsuit to explain, number one, that there's discrimination in the formulation of the permanent impairment, in that the permanent impairment ratings that are provided to women injured workers are largely provided by male qualified medical evaluators. That's number one. And then number two, that these permanent impairment ratings that are provided for by male qualified medical evaluators do not fully and adequately and completely consider the harms, the impairment, the loss of use, the loss of functions that are unique to women. And that is found to be well true, and it may be related to the fact that men simply don't have a full and comprehensive understanding of harms that are unique to women, because many qualified medical evaluators are male compared to a small portion of qualified medical evaluators who are female. And the Page versus Perry Soto lawsuit provided some statistics about the distribution of qualified medical evaluators. Now, the next case that I want to share with you has to deal with a qualified medical evaluator who was replaced from the case, and a new panel of qualified medical evaluators was ordered based on evidence in the QME's report of racial bias and nation of origin bias. Now, this is an important case for all of us to understand because of the frequency with which we're commonly encountered injured workers across the face-to-face evaluation who are from a different nation of origin, who are of a different race, who are of a different gender, who otherwise might be considered to be in our social outgroups. But the days in which we can provide opinions and conclusions that overtly and obviously express such bias are now over, and this is one qualified medical evaluator who was quite overt in his racial bias in his opinions and conclusions. And so let's take a look at some of the comments that this particular qualified medical evaluator made that resulted in his goose being cooked, so to say. So this is a case that involved bias against race, nationality, and country of origin. So in the history section of the report, the qualified medical evaluator stated that the examinee was born in Mexico, he has a 9th grade education, he is not in this country legally. So this is a comment related to the injured worker's immigration status. Now, of these historic facts, which of these historic facts are reasonably relevant to the industrial injury? This was a qualified medical evaluation that was ordered under Labor Code 4060 for a compensability determination, an AOE-COE determination. And how are these historic facts relevant to the AOE-COE determination? They're not. Rather, what this qualified medical evaluator is doing is he's ramping up facts and data that are going to support his opinions and conclusions, which are going to be revealed to be strongly biased on nationality, country of origin, and the examinee's immigration status. So let's look at some more of the comments made by this qualified medical evaluator. The qualified medical evaluator went on in his description of the examinee's capacity for activities of daily living by stating that the examinee is able to drive without trouble, but he does not have a driver's license. Now, of these two sentence stubs, which of these sentence stubs relates to the activity of daily living? The first one does, doesn't it? The first one tells the reader of the report that the examinee is not limited in the activity of daily living involving driving. But what value does this comment that he does not have a driver's license add to the activities of daily living discussion? It adds nothing. In fact, here the qualified medical evaluator is just setting up his opinions and conclusions, which are going to be to burden and to punish this particular examinee. This qualified medical evaluator has placed persons who do not have a driver's license in his social outgroup. If you recall back to session number 3, we talked about social in-groups and social outgroups. So not having a driver's license places this examinee in the qualified medical evaluator's social outgroup, and the qualified medical evaluator, by design, is going to punish and burden this injured worker with an unfavorable determination. And here, the qualified medical evaluator provides evidence of the examinee's social outgrouping. On exam, the qualified medical evaluator stated that his exam is not valid. There are positive Waddell signs with giving way and blocking of motion, and you can tell that the qualified medical evaluator is stacking opinions and conclusions that are going to ultimately support his final opinion and conclusion against industrial injury, AOE, COE. And then finally, at deposition, the qualified medical evaluator put the nail in his own coffin by stating that the examinee is not a credible man, that his exam was totally unreliable, that his hands were soiled and calloused, indicating that he was doing something, And here was the final straw that broke the QME camel's back. He testified that indeed, consistent with the allegation of the injured worker, he indeed asked the examinee if he was a citizen of the United States. Now, let me ask you as a qualified medical evaluator, you frequently do evaluations for which the determination that you're hired for has to do with the compensability determination under Labor Code 4060, the AOE-COE determination. How is it relevant to the evaluation if the examinee is a citizen of the United States or not? How is that even relevant to the evaluation? It's not. And yet this qualified medical evaluator was pursuing this line of questioning to support his final opinion and conclusion that there was no industrial injury. And he was stacking his opinions and conclusions with facts and opinions based on social outgrouping, that this particular examinee is not a citizen of the United States, whereas the qualified medical evaluator is a citizen of the United States. So this is a case that involves several examples of social outgrouping and how social outgrouping results in punishment and burden for the target of that implicit bias. So the applicant alleged that bias influenced the opinion that no orthopedic injury had occurred, and you can, I'm sure, imagine the outcome of this case, and that was that the QME was replaced. Now, I've given this presentation to legal groups as well, and many times I've received the same question over and over, particularly from applicant attorneys, and they are convinced that they're reading reports from the same evaluators over and over again, where the evaluator has a specific type of bias. And the question that I get over and over again is, how can you prove bias in the opinions and conclusions of the medical legal evaluator? Well, in this case, the bias proved itself. The bias stuck out like a sore thumb itself. Now, in most cases, most qualified medical evaluators are not going to be so overt in their discriminatory opinions and conclusions as in this particular case. And moving forward, all qualified medical evaluators are going to have to take a second look, a third look, and a fourth look at their opinions and conclusions before finally sending them out in the mail to confirm that those opinions and conclusions are not in any way influenced or impacted by any of these targets of bias, such as in this case, which involved racial bias, country of origin bias, and immigration status bias. So these multi-layer evidences of bias resulted in this qualified medical evaluator being replaced. So doctors, let me ask you to take a look back at one or more of the recent qualified medical evaluations that you've been involved with. And as you sat across the face-to-face evaluation with the injured worker, have you ever become consciously aware that your examinee was in a social outgroup, was being considered by you to be not like you, to being different from you, different in gender, different in age, different in body physical condition, different in national origin, difference in immigration status, difference in possession or non-possession of a driver's license? How many times have you sat across from an injured worker and socially outgrouped that injured worker? Or how many times have you socially in-grouped that injured worker on the basis of one or more characteristics of that injured worker? It's these positioning of the injured worker into one or more of your social in-groups or one or more of your social out-groups that influences unconsciously and almost irreversibly and almost imperceptibly influences your opinions and conclusions, and it could do nothing else, because these biases, these implicit stereotypes, these preconceived notions that we have are so deeply ingrained of us, and they trace so far back in our history as to be just a part of who we are. But how fair is that to the person who's sitting across from you. I can't tell you how many times I've gone to the face-to-face evaluation after reading the medical records, after reading the cover letters, after preparing the examination template, only to get to the face-to-face evaluation and realize that this injured worker is nothing like I expected them to be. So the new era of the medical legal evaluation being imposed on us by law now, if not by moral responsibility, now by law, is being imposed upon us to eliminate these biases and stereotypes from our opinions and conclusions, with the ultimate intended effect for us to be able to provide benefits to injured workers, whether those benefits be $0 or $1 million. Okay, even $0 is a benefit for purposes of this discussion. To provide benefits that are accurate, and that are not influenced by all of this muck and junk, that are accurate. So in our next session, in the interest of accuracy, I want to share with you a couple more examples of bias in the workers' compensation system regarding racial bias, claims bias, and disability bias. And then we're going to get to the whole conclusion of this series, and we're going to discuss at length some steps you can use and some principles you can rely on to help yourself eliminate bias from your opinions and conclusions. Now, in the meantime, I have a homework assignment for you, and I want to ask you to start paying attention and to start giving some consideration to your implicit biases based on various persons, and then based on the characteristics of those various persons. And if you can just start to become aware of how you socially categorize people and various characteristics, that can serve as a perfect starting point for helping to eliminate these stereotypes from your opinions and conclusions. So I have a great session for you next time, one I'm hoping that you will benefit tremendously from, and one that's going to bring a successful conclusion to this groundbreaking and historic discussion series that we've had over the last several weeks. So for today, this is Dr. Perry Carpenter. I want to thank you for taking the time to join me. I want to thank you for taking the time to view this video all the way to its conclusion. The fact that you're at the end point of this video demonstrates your commitment to excellence as a qualified medical evaluator. And for that, I and the system thank you, because we need good, top quality, qualified medical evaluators in the system. So I'm looking forward to being with you on our next session. And for now, this is Dr. Perry Carpenter. I'm wishing you best of success in your career as a qualified medical evaluator.